Okay. All right, let's start. Now we went through the shadow docket. Everybody following? Emergency appeals. Now let's get to the actual cases, and we're going to try to get through them all. Now here's the first case is the birthright citizenship, which is sort of a misnomer because they weren't really deciding birthright citizenship. They were deciding the very thing that Neal started us out on, which is the idea of injunctive relief that pauses the president's executive orders while the case rolls its way through the system. And so therefore, the president is looking to implement the deportations, the firing of people, the elimination of transgender people serving in the military, and a federal district judge stops the proceeding, and Donald Trump goes nuts. He's going, you can't stop me. Not one single judge can stop me. And so that was the debate, right? That he's saying, I'm the president, I received a mandate, I have all these things I want to do, and a single federal judge can't put a stop nationwide. It's one thing if you want to stop something but the parties before me, but not nationwide. So the birthright citizenship case started out as an emergency appeal, and then I don't even know how that happened, and all of a sudden it became an actual case that got argued very quickly, right? It got argued very quickly and got decided at the last case of the year. And in the end, we now know that the 6-3 majority said, yeah, federal district judges can't put a pause, what's called universal injunction, on the whole nation. They can only affect the parties before them. Neal?
Yeah, so just so everyone should know, this was one of my nonprofits cases, our Georgetown nonprofit, the Institute for Constitutional Accountability and Protection, so take what I say with a grain of salt. But we went into court and basically said Trump is trying to eliminate birthright citizenship, this guarantee that everyone has thought since the Civil War that if you're born in this country to parents who are here, whether you're on a visa or you're here on an undocumented basis, you're a United States citizen. That's exactly what we fought the Civil War over. That's what Representative Bingham says when he writes the 14th Amendment, those lines at the beginning. So we went into court and said that. We won right away. The court then did, as Thane says, issue this nationwide injunction. So we filed our case in Maryland, but it now governed the entire country. Anywhere in which Trump wanted to try and take away birthright citizenship, we had a court order that said you couldn't do that. The Solicitor General then did that emergency race that I described to you earlier up to the Supreme Court. The Supreme Court didn't want to hear the merits. They just wanted to hear, as Thane says, this question of a nationwide injunction. And as Tiffany tells us, that in an opinion written by Justice Barrett for 6 justices, the court said you can't have this kind of nationwide injunction for at least private plaintiffs. Justice Jackson writes that dissent, saying it's the end of the rule of law. I think, even though this is one of the cases I care most about, I don't think that this is, I think that was going a bit too far. The court was pretty careful to say there are 3 different paths to getting broad relief. One, you can file a class action, which is an idea that says we're filing on behalf of many people, not just on the one person, the plaintiff, and you can get relief there. Second, the court says that state attorneys general can sue the president and possibly get nationwide relief. They've left that question open. And in this climate, there's always some state attorney general who wants to take on a president. We saw in the last administration, and we'll see in this one. And then third, and most importantly, the court left open the possibility that challenges under the Administrative Procedure Act can result in a nationwide injunction because that precedent goes back to the 1950s. And many of these executive decisions are implemented by agencies, and you can sue the agencies over them. So I think the time will tell exactly how extreme this decision is. I'm certainly no fan of it, but I'm also no fan of the rhetoric right now which says end of the rule of law. And I do think there was a kind of bizarre coalition between the hard left and fueled by Justice Jackson's decision and President Trump, who immediately declares victory and says, this is, I can now do anything I want with respect to birthright.
You're right. What he actually said, which could come back, he may not win this one. He actually literally said, he gave an illegal opinion. I don't know how he did this. He said, the 14th Amendment only applies to the children of slaves. He explained this. He just told everyone, I won, I won. Now, the case wasn't even about birthright. It was just, as we said, it was about the injunctions. But I don't think he knew that. So he just showed up and declared victory, and he said the 14th Amendment applies only to slaves. I actually think he's going to lose this one, and that'll be a great soundbite.
There are a lot of white people who would find that surprising.
Well, also, just quickly, there is a case from, 1898, of a Chinese American whose parents were not American citizens, who was born here. So in 1898, we said a Chinese American is, in fact, a citizen under the 14th Amendment, and he was not black, and he was not had anything to do with the Civil War or slavery. So let's just move on now to
maybe just one historical point about this. One historical point about this very crucial question. First, it's really significant that Neal tells us that time will tell. We don't know what the practical effects of the decision will be. But it is true that this question of whether or not the president has to obey a decision beyond the parties to the case goes back to Hamilton and Jefferson. This new book that's coming out in October, The Pursuit of Liberty, is about how the battle between Hamilton and Jefferson defined all of American history. And when it came to the Supreme Court, Jefferson insisted that he only had to apply Supreme Court decisions to the party in the case, but not more broadly, and that as president, he could make up his own decision about how to interpret the Constitution. John Marshall is so afraid that Jefferson is going to defy him that in Marbury versus Madison, he does these somersaults to avoid ordering Jefferson to do anything, because he says, I'm not fond of butting my head against a wall in sport. And that position, it's called departmentalism, is embraced by Abraham Lincoln, who says he's not going to apply the Dred Scott decision across the country, but only to the parties in the case. It's embraced by Franklin Roosevelt and by Ronald Reagan, by all of the presidents that are viewed as constitutionally transformative in American history. So it's not unprecedented by any means for a president to say, I don't have to apply Supreme Court decisions more broadly than they actually appear. But that leads to the broader question, which maybe we can tee up next. The court is clearly afraid of being defied by President Trump. And President Trump had threatened to defy lower court decisions, and of course there have been attacks on lower court judges and calling for their impeachment. There was that remarkable moment when all 9 justices converged to say that President Trump had to facilitate the return of Mr. Garcia, a carefully chosen word, because they clearly were afraid that the administration was going to defy the lower courts. My sense is that Chief Justice Roberts is very eager not to be defied. His hero is Chief Justice Marshall. Well, he's an
institutionalist, right?
He's an institutionalist. His hero is Chief Justice Marshall. He has Marshall hanging in his chambers. He's embraced Marshall as his model. And like Marshall, he's not fond of butting his head up against a wall in sport, and he's trying to pick his battles to avoid ordering the president to do something that he won't do. Now, the question is whether he should be viewed as Chief Justice Marshall, a canny tactician who's kind of keeping the court's powder dry, or as Steve Loddock said in our review last night, as Neville Chamberlain. And I'll leave it up to my colleagues to decide.
So before we leave, there's one thing that you just reminded me of, and it's actually, there's a case tomorrow in New Hampshire. By lifting the nationwide injunctions, it does create, I think, a headache for the Supreme Court, because they, seems to me, now have an obligation to fast track. These things got to move faster. So I think Sotomayor said in her opinion, she said, all right, well, let's just roll with these class actions. Let's go, let's go, let's go, because if you can't enjoin it, remember the disparate result. You're born in one state and your parents are not citizens, you're not a citizen. You're born in another state that interprets it differently, and all of a sudden you're a citizen. So we've got to fix this. So the Supreme Court's going to have to get through birthright citizenship faster. And guess what? Tomorrow in New Hampshire at 3 p.m., they're trying to certify a class to start this process. All right, let's move on to...
One quick thought, just really
oh,
quick.
God.
Sorry.
So you guys brought the sleeping bag, right? You've got a note with that. Guys, you know we're not even close. All right.
One of the things that's so interesting about these nationwide injunctions is the way that they are employed by both sides of the political divide. If you've noticed over the years, you see that during a Democratic administration, it's very common for Republican attorneys general to run to the Fifth Circuit, whereas during a Republican administration, it's very common for Democratic attorneys general to run to the Ninth Circuit, or perhaps some of the others. And one of the things that's been frustrating for me as transparently a liberal, is watching some of these decisions come out of a nowhere courthouse in the middle of Texas, and they enjoin action over the entire country. But if I were conservative, I would be deeply frustrated by seeing a decision come out of Seattle that does the exact same thing. And so, you know, it's kind of hard to really wrap your arms around this decision in terms, if you're thinking about it politically, to sort of try to sort through how to feel about this, because Barrett's opinion is not absurd. It's not. But you know, when you're thinking,
but it's also the case in which, you know, all.
Sorry,
They're gonna kill these
it's
people.
interesting.
We'll be
Seriously,
back.
did I remember I said friends? Forget it.
So, but during the Biden administration, you know, all the liberals were like, you got to stop. You know, the conservative judges in Texas were issuing nationwide injunctions, and it was really grinding the Biden administration to a halt. The question is, why now? Right? In other words, during the Biden administration, the Supreme Court didn't kill nationwide injunctions, and it does it now, and it also does it in a case in which the law is pretty clear, right? So, you know, a lot in the Biden administration, there were arguments on both sides, and the Supreme Court didn't do anything. This is a case in which the text, the legislative history of the amendment, and the Supreme Court all very clearly say birthright citizenship means if you're born in the U.S., you're a citizen, period.
All right, one last thing. Remember, it was, in fact, Justice Kagan during her nomination hearings in which she expressed a problem with nationwide. So that's why when Tiffany
Every
said,
Solicitor General has.
Right, exactly, right. So I'm saying it's not like when you said, it's not like Barrett is insane, like everyone has had this view. All right, the Tennessee case dealing with gender-affirming care. This is the case in which Tennessee passed a statute that said, you want to transition to a different gender. If you're an adult, good luck to you. You want a surgery, it's up to you, you're an adult. If you're a kid, let's not even deal with surgery. Hormone blockers, puberty blockers, hormonal therapy. We don't trust it, we don't think it's safe, we don't want any Tennessee kid doing this. By the way, those same drugs can be used by other kids in Tennessee for other reasons, but not to change gender, right? So apparently some of those drugs work nicely for anxiety, right? So you could be taking for anxiety, but they'd have to check with the kid. You're not doing this because you want to change your gender. So the Supreme Court ended up ruling 6-3, right, that in favor of Tennessee's decision, saying essentially that the state had a compelling state interest to protect its kids, I guess, and the other argument is, but the 14th Amendment is being violated because there's an Equal Protection Clause argument here, and that seems to me a very strong thing, and the court said, well, forget it, we're really worried about the kids. In fact, I would say two things about this term. One was it involved a lot of kids. Some of the cases all involve kids. Here's kids. And it also was a very good year for social and religious conservatives. All right, anyway, what do you guys have to say? Jeff, you were interested in this.
Well, it's so interesting constitutionally and also in terms of the culture wars. So constitutionally, the court rejects the centerpiece of Justice Ruth Bader Ginsburg's vision of gender equality. That was most interesting to me. Justice Ginsburg had argued that laws that reinforce traditional stereotypes are constitutionally suspect. And that was the basis for her criticism of Roe v. Wade. She said that it shouldn't have been decided on privacy grounds, but because laws that prohibit women from deciding to do what they want with their bodies and to make decisions about their careers reinforces gender stereotypes, laws on abortion are unconstitutional. The court in Dobbs rejected that claim on the ground by citing a case called the Geduldig case that said that pregnancy discrimination doesn't discriminate between men and women, but between pregnant women and non-pregnant persons. And that technicality was the core of the Dobbs majority's response to the dissent, saying it can't be gender discrimination because it's not discrimination on the basis of sex. It was the same Geduldig case that gets resurrected in the middle of the Skrmetti case, and Chief Justice Roberts says that—
Skrmetti case is this case.
This case involving
gender
whether you can have access to these drugs. Chief Justice Roberts says this only just doesn't discriminate on the basis of sex, but on the basis of purpose and age. You can't have the drugs if you're young, if you're a teenager, and you also can't have them for the purpose of transition, but you can have them for other purposes, like anxiety or stopping, hirsuteness in women as long as they're not trying to transition. So for that reason, the chief said, we're not discriminating between trans people, but between people who want to use the drug for one purpose or another. And in the process, the dissenters said, but Justice Ginsburg rejects this idea. You don't have to cover everyone in the class, but if the main purpose is to discriminate against individuals who want the drugs or who want pregnancy, then it is sex discrimination. So the big picture for me was that the court totally rejected Justice Ginsburg's anti-stereotyping jurisprudence, making it impossible to resurrect that before this court as an argument against abortion restrictions. It also rejected the idea that trans people are a suspect class who, like women or racial minorities, deserve special constitutional scrutiny. And Justice Barrett, in her concurring opinion, was very methodical in saying, look, we're not going to recognize new suspect classes unless three things are present. It's an immutable characteristic, it's not related to ability to contribute to society, and there's a history of discrimination. And here she said, here transgender status or one's gender identity by definition is not immutable because people are trying to change it. And it's not, and then most importantly, she said there's no history of de jure discrimination, in other words, of recognized discrimination written into the law. Justice Sotomayor responds, well, transgender status is a new thing. There can't be this formal history. That's too high a bar. But broadly, the conservatives, and Justice Alito and the others joined this, said we're not going to add new suspect classes. The list is closed, and without a really clear history of de jure discrimination, you can't get heightened scrutiny. So that's very important doctrinally because it suggests that there aren't going to be new groups added to the list. But then there's this whole question of the empirical evidence. And Justice Thomas had a long concurrence saying this evidence is very disputed. Europe is not allowing these treatments for young kids as young as 11 and 12, and it's just too uncertain for courts to weigh in one way or the other. The states are entitled to make up their own minds. And even Justice Kagan, who thought that it should have been examined more closely by the lower courts, didn't say automatically that the statutes would fall, but just that you had to evaluate their actual health benefits or whether they were based by animus. It's a lot, I know, but it was a really interesting case at the center of the culture war, and the court basically said, we're not going to be